everybody. Welcome to what I'm going to refer to as the LOMAD favorite things. And I'd like to introduce to you our incomparable producer, director, sound technician, video producer, Najee Walker.
Hello.
Who has done a fantastic job for us. Najee, why don't you say hi to everybody?
Hello. It's finally good to be in front of the camera for once. I just really wanted to say hello to everyone, really introduce myself to you guys before we get started with the rest of the video.
And what are your favorite things, Najee?
Oh, my favorite thing is doing this show.
And I paid him, but not to say that.
No, it is a lot of fun. It definitely is.
Well, you do a fantastic job. Thank you very much.
All right.
Super. So with that, we will introduce you to our first attorney, and I'm not sure who that is because we're recording this out of order, but I'm sure it's somebody fantastic. I can guarantee you that.
Yep. Have fun.
Thanks.
Hi, my name is James Cousins, and I'm an associate with the law offices of Melissa Day, and I'm here to talk to you briefly about reading audiograms. Now, I know that hearing loss cases are not the most common workers' compensation claims, but knowing what an audiogram is telling you about a claimant's hearing loss can oftentimes be incredibly valuable to you in deciding whether you want to accept a claim, how you want to litigate a claim if you're going to deny it, and basically, essentially how you want this case to resolve. So the first thing we want to talk about generally before we get into the great visual aids that I have today are the two types of tests that can be performed generally that we're going to see for testing hearing loss. The first kind of test is what we call a pure tone or an air conduction test. That's when a patient goes into a sound booth, they're going to put headphones on them, and they're going to give off tones at various decibel levels and at various frequencies, and when the patient hears the tone, they're going to press a button. And that's going to start plotting on an audiogram what that patient's hearing threshold is. That's what's going to create the charts that we're going to look at in a minute. The second kind of testing is also done in a booth, but it's called bone conduction testing. Instead of using headphones, they're going to be placing a small vibrator on the skull behind the ear, and they're going to use the vibrating drum to begin to basically pass the tone into the head so that it can be registered by the cochlea instead of having to have that sound pass through the middle ear. So instead of vibrating the eardrum to have that energy from the sound pass into the cochlea through the ear canal, that sound energy is going to be passing to the cochlea directly, essentially through the vibration of the skull. Air conduction studies are used to determine what a person's hearing loss is if there's some reason to believe that they have a conductive hearing loss. And then we'll talk about that when we get into looking at our slides. So let's look at our first audiogram. So this is our first audiogram, and our first audiogram here shows what normal hearing is. Now we know the board's formula indicates that the normal hearing threshold is about 25 decibels, but that's not always true. But normal hearing is essentially going to be flat pattern, and you see left and right ears here plotted as blue and red lines respectively. Let's look at our next one. Our next one is presbycusis. Now you see presbycusis here, we have normal hearing in the low frequencies between 250 and about 2000 hertz. And then we see a huge decline in hearing up into the high frequencies. This is what I call the ski slope pattern. The ski slope pattern is generally presbycusis, but as we'll see later, it can also represent other things. Let's look at our next one. Okay. This is what we call conductive hearing loss. We talked about air conduction studies and bone conduction studies. The brackets at the top are bone conduction. Those are where the patient registered sound during the hearing test when their skull was being vibrated. I know that sounds funny, but that's how it works. And then below here, these X's and O's, this is where the patient registered sound when they were using air conduction. What this study represents, what this hearing test represents, is that this patient has some kind of conductive hearing loss, a buildup of wax, a damaged eardrum, something like that. And of course, this is not causally related to employment if you have waxy ears. Let's look at our next one. This is a diseased ear. And in fact, this is Meniere's disease because it's asymmetrical. You see that at the top of the audiogram, the blue line looks kind of normal, and then down here, the red line shows a huge low-frequency hearing loss. Meniere's disease is typically asymmetrical. It's typically sudden loss of hearing, and it's typically low-frequency hearing loss. However, most disease processes that show up on audiograms tend to reflect very substantial low frequency hearing loss. So if you see an audiogram that has a lot of low-frequency hearing loss, there's a good reason to suspect that the claimant has some kind of disease process going on. Hearing loss due to a disease process is generally, or almost always, not going to be related to employment. Now let's look at the next one. This is what somebody's hearing loss looks like if they've been taking ototoxic drugs. It may surprise you to know that there are lots of medications out there that are ototoxic, meaning that they damage your hearing. Some of those are very commonly prescribed drugs, including beta blockers and other high cholesterol medication. Heart medications can do this. Also using certain types of steroids on a frequent basis can cause damage to hearing. So ototoxicity, and have a look at this, this doesn't look too much different from the pattern of presbycusis, which is old age hearing loss. Let's look at the next one. This is the one that you don't want to see. This is noise-induced hearing loss. And note that there's a very specific pattern here. See this dot right here, 4,000 hertz? That's where the most hearing loss is going on. And see how it gets better in the high frequencies, and then it gets better in the low frequencies? This is a traditional pattern of noise-induced hearing loss. Now, not all noise comes from industry, not all noise comes from employment. And in fact, we're going to talk about it in a little bit. When you see a noise-induced hearing loss pattern with some asymmetry, so if this blue line and this red line didn't line up, so let's say the red line looked like this, but the blue line was a flat right across the top here, that would be an asymmetrical loss of hearing with one side showing evidence of noise-induced loss, the other side showing none at all. That might be caused by somebody discharging a firearm when they're, if they're hunters, they shoot skeet or trap. Discharge of a firearm causes an asymmetrical hearing loss. So asymmetrical hearing losses that do show the pattern of noise-induced loss typically are not supposed to be coming from employment, because when somebody's working in a noisy environment, it's sort of understood, and it's hard for them to ever imagine that there's an asymmetrical source of noise. It's not like most people go to work and there's something really loud on this side and they work there standing still for 8 hours a day, so that one ear shows no loss of hearing and the other ear shows a substantial loss of hearing. That's a really unique circumstance. Now let's look at the last one. The last one is what we call a mixed loss. So if you look at this pattern, it looks a lot like the ototoxicity pattern, except it's shifted down. We also see that there's an air-bone gap, just like when the person who had wax in their ears or some kind of conductive hearing loss, this gap between the line of the air study down here and the bone study up here, that means that there's some conductive hearing loss here. Also, we know that look at this, there's a substantial loss at 4,000 hertz. There could be some noise-induced hearing loss shown in here, but this is what we call a mixed pattern of loss. This is seen very often, and we know that IMEs, and as well as treating doctors, oftentimes will indicate that a patient shows a mixed loss. This pattern doesn't look like noise-induced loss. It looks like presbycusis. It looks like it could be ototoxicity. It also looks like there's a conductive loss here. You can't rule out noise-induced loss here, but you also have an equally hard time, in our opinion, ruling it in. So when you see a pattern like this, particularly where you see this air-bone gap, you know that the air-bone gap component can't be related to noise exposure, and it's going to be very hard for the claimant to prove what part of this is related to exposure. But again, when you're assessing the case before you send it for an IME, it's always good to know what you're looking at. It's good to know how you're going to defend your file, whether you can defend your file, and how vigorously you want to defend it, and on what points. So if you see an audiogram like this, or any of the other ones that we discussed, it's going to help you assess your case, and it's going to help you decide what you want to do with it. And of course, you want to give it to the very best counsel possible, the Law Offices of Melissa Day. Thank you.
Hi, I'm Brian Prince. I'm an associate attorney here with the Law Offices of Melissa Day. I'm here to talk to you about one of my favorite things, C4 auths. Another one of my favorite things are memes, as evidenced here. So, that being said, the first question is really, what is a C4 auth? And the short answer is, it's a board form for a treatment authorization. And set forth in this book here, long ago, not so distant past, before the dawn of the medical treatment guidelines, all treatment costing more than $1,000 required special authorization by Form C4 auth. The coming of the MTGs overwrote these requirements for sites of injury governed thereby, which now include the knee, the shoulder, carpal tunnel syndrome, non-acute pain, and the entire spine. As such, a A C4 auth is still required for all treatment costing more than $1,000 for sites of injuries that aren't governed by the medical treatment guidelines, as well as for the 11 special exceptions to the medical treatment guidelines listed in the regulations. So, our love for the not the medical treatment guidelines, but for the C4 auth is purely sarcastic. And that's largely because the burden on the doctor is so incredibly low. All a doctor has to do to have a valid C4 auth is to provide a statement. It says explanation, but we know the doctor's really just going to staple a treatment report to it and say that, oh, it's good enough, because it's supposed to say that the treatment required is medically necessary and appropriate for the claimant. That's a rather low bar. So the other thing is that the defenses that we know and love, that the doctor hasn't met his burden of proof or that the treatment isn't causally related, do not apply for C4 auth requests. So the only way to properly defend against a C4 auth on its face is with a contrary medical report. So there used to be a requirement as well that you file a C8.1a, but that's no longer the case. The case law has shifted and kind of moved away from that requirement, and subject number 0461085 went and essentially codified the change, given that the board has found that, given the fact that the C4 auth denial and the C8.1a say essentially the same things, C8.1a is redundant and unnecessary at this point. So the question for defense really comes down to IME or not to IME. I mean, that is the question. And the reason that there actually is a question here is section 325-1.4b of the regulations. And that says that a C4 auth really only addresses the question of medical necessity. It doesn't even get into the issue of causal relationship. And so if you actually paid attention to the language of the order of the chair, and I, in preparation for this presentation, went back and did just that, it actually says right on there that if the treatment or if the condition isn't an established part of the claim, we don't have to pay the bill. And it's also codified in Third Department case law per Pinkashov that the order of the chair only governs the issue of medical necessity and not causal relationship. So that defense still remains a viable option to try to get out of these things. So, I mean, we had a case recently where there was a request for a whole body bone scan in a hip case. And the judge went and authorized it because we didn't have contrary medical. But she also slipped in the language that the carrier is liable for payment of those services. So, given the fact that a lot of the comp judges aren't as nuanced as they were supposed to be, instead of having treatment being authorized that we're not going to be on the hook for, considering how hard it would really be to get the entire claim established for the whole body, we now have a decision that we have to appeal. So it may very well be worth considering letting some of these C4 auths for unrelated treatment or treatment that we don't think is related go to order of the chair. On the other hand, for cause-related treatment, at a bare minimum, you'll need to get at least a record review, at least 30 days, and deny the request within 30 days, because the defenses of causal relationship and burden of proof really aren't viable. I mean, there are a couple procedural shenanigans that we can help you with, such as the request not being properly submitted to the board or not being properly signed, stuff like that. But aside from that, you really will need medical evidence to counter C4 auths for cause-related treatment. So I guess in a way you could say that procedure is one of my favorite things. So thank you for your time, and I hope to talk to you soon.
Hi, everyone. This is Josh Sroka with the Law Office of Melissa Day. Just here to present for LOMAD on the bench, and I wanted to touch on a few things with labor market attachment again, specifically about developing the record regarding evidence of attachment. As we're all aware, attachment to the labor market can be demonstrated by credible documentary evidence showing that a claimant is actively seeking work within his restrictions through an independent job search that is timely, diligent, and persistent, or is actively participating in a job location service such as New York State's Department of Labor's Reemployment Services, the One Stop Career Center, or a job service commonly utilized to secure work within a specific industry, or is actively participating in Access VR, formerly known as VESID, or other board-approved rehabilitation programs, or is actively participating in a job retraining program, or is finally attending an accredited educational institution full-time to pursue employment within work restrictions. Obviously, whether or not a claimant is actually maintaining attachment to the labor market sufficient to justify continued compensation benefits is a factual determination that the board resolves. As the Court of Appeals has held, by finding alternative work consistent with his or her physical limitations, or at least showing reasonable efforts at finding such work, the claimant can prove to the board that the cause of his reduced income is disability rather than unwillingness to work again. If the claimant's work search has been unsuccessful, the board must also consider whether the claimant has demonstrated a nexus between his disability and his inability to find work. We recently had a case that I wanted to use as a case study. This case has been particularly troublesome as the judge is extremely hostile and extremely claimant-oriented. In this case, we had come on for a hearing in March of 2018, and it was noted that the claimant had failed to produce a work search as previously directed by the board, and we asked for a suspension based upon same. However, at the hearing, the claimant presented a C-258, which is their work search record. It is noted there is case law that supports a position that producing the evidence at a hearing is insufficient when a claimant has been directed to produce it within a certain amount of time. However, the judge was unpersuaded by that evidence. Thereafter, at the hearing, the C-258 indicated that the claimant had applied for approximately 7 jobs between January and February, most of which were online. The board noted the jobs were in security, customer service, sales, stocking, and driving. The claimant thereafter had attached a handwritten letter indicating he had been trying to contact someone at Access VR. However, that individual had not been getting back to him. The claimant indicated he had also been volunteering driving the elderly around. And he produced a mileage reimbursement as evidence of that activity. The claimant's counsel asserted at this hearing that the claimant was about to start a new job. At the time of that March 8th hearing, the case was continued for testimony on labor market attachment, as we believed that the C-258 and evidence submitted was insufficient as proof of same. At the next hearing in April of 2018, the claimant testified that he was attached to the labor market because he was driving the elderly around as a volunteer transportation driver. Again, it was noted that this was for 2 to 4 hours a day, and again, he had produced evidence of the reimbursement to prove that he was actually performing this task. The claimant then stated he began working at a warehouse box-type store, handing out samples to customers as they shopped. He started this in March, and he quit in April. According to the claimant, he stopped working because it was bothering his back too much. It's noted that the claimant testified he discussed leaving this job with the doctor, who felt it was too much for the claimant to do. However, at the time of the hearing, there were no restrictions in the board file regarding the claimant's ability to work. It's noted that after the hearing, on the same day, the claimant went to his doctor's office and got a note that was backdated to a date before the April hearing, which did list restrictions on the claimant's ability to work and made the job working at this box store handing out samples be inconsistent with his restrictions, as in an effort to show that he shouldn't have been working the job in the first place. The claimant testified once he quit this job that he alleged he could not do, and it is noted again, the doctor's note did not actually take him out of work. He was not found to be totally disabled at any point during this testimony on labor market attachment. He was found to be suffering from a temporary partial marked degree of disability. Since quitting the job, he testified he had finally contacted someone from Access VR and set up an appointment, but he had not gone. And he testified he went to a job fair. The claimant's counsel argued since he worked for approximately 4 to 6 weeks, that should be evidence of labor market attachment. He should be found to be attached. We argued that the evidence was wholly insufficient to support attachment. We noted that his work search had no documentary evidence to support the alleged jobs he applied to. And we noted that he quit his job without a doctor taking him out of work, nor was there any indication that the work he was doing was outside of his restrictions. And we argued he voluntarily withdrew from the labor market. The judge decided that the claimant's work during that time frame was sufficient to support awards. And he made awards reflective of reduced earnings and then continued payments at a TP rate. We appealed the judge's decision. On appeal to the board panel noted that since the doctor had submitted the backdated note, that note seemed to concur that the claimant had difficulty with the job, but the board panel highlighted that the doctor still found the claimant to have a temporary partial degree of disability. In other words, he was not totally disabled. The claimant indicated that he stopped working at the box store in April, but the jobs that he applied to after he had voluntarily quit his job were in work as a delivery individual and a driver. And there was no evidence submitted that this was actually in compliance with the restrictions that the backdated doctor's note now listed were applicable to the claimant. Additionally, the board noted that there was no supporting documentation to substantiate the independent work search. We know usually you would have, since they were online applications, you'd have the email confirmations of receipt of the application. This claimant testified that despite doing the job applications on Indeed.com, he did not receive any confirmation emails back. At this point, most judges realize that service actually does submit email confirmations that your application has been submitted. In follow-up on our questioning, we asked the claimant specifically, can you show us the emails where you applied to the job? The claimant was unable to do so. The board noted that due to the lack of supporting documentation to support the allegation of applications to these jobs, there's insufficient evidence of documentary attachment to the labor market. Additionally, the board noted that the simple act of setting up the appointment with Access VR was insufficient. Therefore, the board panel reversed the judge and rescinded the continuing payments that were noted in the decision. We just wanted to highlight this case because there were a few issues going on. Specifically, as previously mentioned, we had a judge who was very hostile to the carrier and the employer simply because he seemed quite inclined to rule in favor of the claimant. Here, we wanted to focus on the testimony from the claimant because we had a feeling that the judge would be ruling against us. So when we went in, we really focused on developing the record in a manner that would support an appeal, because we knew we'd really have to leave it up to the board panel to make the accurate and appropriate determination on the law. In this particular case, that worked out. The issues that we highlighted that we said were deficiencies with the C-258 were specifically highlighted by the board and the reasoning to overturn the judge's decision. They also were amenable to our points on the doctor's backdated note that was submitted as evidence of restrictions. And it was noted that the claimant was still partially disabled, not totally disabled. And finally, we were able to get the claimant to testify that he had never gone to Access VR at the time of his testimony, nor did he have continuing evidence of work with that specific agency or any one-stop. This was sufficient to get the judge overruled. Therefore, sometimes your strategy will really need to be, when you go into the hearing, to develop the record as best you can regarding the claimant's work, applications, and searches in an effort to prepare for the eventual appeal if you know the judge is going to be hostile or most likely rule in the claimant's favor. Thank you.
Hello everyone, my name is Henry Tilson. I'm an associate attorney at the law offices of Melissa Day. I'm here today to discuss with you the ever exciting and sexy topic of jurisdiction. Now you can see I'm all ready to go. I've got my travel attire on with my very sporting cap. because in my mythical travel that we're going to take today, I'm going to use the advantages of airline travel. Now, as most of you know, the workers' compensation system was designed and implemented back in the 1910s before airlines really became a common mode of transportation. And so the issue of the issue of jurisdiction really kind of developed through the issues of case law. And because of New York being having several central hubs of airline travel, we have some really interesting case law that really expands upon how the board has viewed injuries that occur both through the airline travel for employees, such as airlines or stewardess, but also what happens when these airlines are having employees ride on them, but not actually using it for employment, but actually modes of transportation to get to their employment. So before we get started, we have to really look at how the board has defined jurisdiction. Now, the board has looked at jurisdiction as a method of contact with New York State, and I'm sure many of you are aware of this standard, especially with many of you who have claimants who are injured in motor vehicle accidents, either outside the state or particularly truck drivers. In this case, we have several cases that involve airline pilots and stewardess or flight attendants, however they may be called, during the course of their work environment, traveling via airlines. So the seminal case on this really that defines what the jurisdiction, the methods to find jurisdiction, is the Nashco case. And this is actually from 1958. And the board still uses this as standard case law to state that when we're considering jurisdiction, many factors have to be looked at, including the geographical location of the employment, location of hiring, control of employment from the company with an office located in New York, payment of out-of-state expenses, and whether or not the employee is a New York State resident, and then finally whether there is an understanding that the employee will return back to New York during the course of their travel. Now, the case that I really enjoy a lot, and the one that really points this out, is the case that involves an airline pilot who lives in Connecticut and is based out of St. Louis. So completely, you would think, no contacts in New York whatsoever. However, this particular airline pilot lives very close to LaGuardia and actually flies out of LaGuardia using his employer, who in this case is American Airlines, to fly to St. Louis, and then from St. Louis he then pilots the planes to whatever destination that he's assigned to fly. So you would think from the beginning here that the claimant would have no connections to New York whatsoever, but that is in fact not what the board found. What was particularly important about this case was the aspect of how the claimant was performing his duties while he was deadheading from LaGuardia to St. Louis. Particularly, the claimant would sometimes fly in the cockpit. And if any of you are aware or have seen the movie Catch Me If You Can with Leonardo DiCaprio and Tom Hanks, very good flick. There is a whole segment in that movie where Leonardo DiCaprio is impersonating an airline pilot and would actually get free travel on TWA while pretending to be an airline pilot. And he would deadhead in the cockpit from one location to the other. In this case, the airline pilot, the claimant, did the exact same thing from LaGuardia to St. Louis, where he was actually stationed. And while he was flying, he was in uniform. Sometimes he would perform services for the airline. I don't know what the services are. And then, more importantly, he would sometimes be paid during his deadheading. So this claimant developed an occupational disease. It looks like he had some vein thrombosis, and he was trying to get this established. And the board found that because the claimant was flying out of New York State, flying out of LaGuardia, he met the requirements to have jurisdiction inside New York State. So it was really important because it looked at the aspects of where the claimant was actually located in his different journeys between states to do his employment. Another somewhat tragic case that really kind of expands upon this are a couple cases that came out of the flight TWA 800 disaster back in 1996. Some of you may remember that. I was very young when it happened, but I remember it happening. And there were a couple of death claims that were brought on the estates of flight attendants who were on that flight, deadheading to Rome via Paris, where the flight was headed. And in this case, the reverse was actually happening. The estate was actually trying to get these claims out of New York State Workers' Compensation System because they wanted to sue the airline for much more money. At that time, it was capped at $400 a week, and they couldn't get to the big pockets of the airline. And what was very interesting about this case was that the board actually stated that international law, the Warsaw Convention, which was signed back in 1923 to actually adjudicate cases of airline incidents between countries, the board actually said the Warsaw Convention did not apply in this case because they still retained jurisdiction. And that stopped at the board, and it went up further, but in this case the board felt that they had jurisdiction of that case. A final aspect that kind of shows the limits of this issue is a case that was brought where an airline flight attendant who had connections with New York but wasn't flying out of New York and actually hadn't even lived in New York for several years attempted to bring a claim in New York for an injury that happened while she was flying over Cuba. In that case, the board found that her connections with New York were too attenuated because there had been no recent connections with the New York state. She didn't live in New York. She wasn't flying out of New York. She just simply had a few prior workers' compensation cases in New York, and she felt that it related back to those cases. But the board found that there was no jurisdiction at that time. So anyway, this has been Henry Tilson. I hope you've enjoyed my little presentation on jurisdiction. Of course, if you have any questions, please feel free to contact me. I love this kind of work. I actually am an amateur pilot myself, have been since I was 15 years old. So by any means, I hope you enjoyed it, and look forward to seeing you again.
Hi, I'm Katrina Gray. I'm an associate attorney here at the law offices of Melissa A. Day. Today, I would like to make a little presentation talking about something very common in the workers' compensation system, and that is complaints of back and neck pain. Very, very common, and in fact, back pain itself results in costs of many billions of dollars in payments for the medical and disability systems. What a lot of people don't realize within workers' compensation is that when it comes time for permanency ratings, there are classes and severity ratings that are often affected by whether or not correlative medical imagery exists, such as MRIs, which essentially correlate the picture on the MRI, the imagery on the MRI, with what the claimant is actually claiming are their symptoms, their pain. A lot of people don't realize that when it comes time to correlating the medical imagery, it isn't just a question of, for instance, the claimant has low back pain. Often people think, well, if they have medical imagery showing a damaged disc in the lumbar spine, that's good enough, and they can qualify for this particular severity ranking. Well, the same thing applies as far as a lot of people thinking if one has imagery of a damaged disc damaged disc or damage to the spine in the cervical spine region. Often people will think, well, that's good enough imagery to show that the claimant's neck pain is essentially validated by the imagery, that it correlates. Well, the problem with that is that when it comes to the different levels of the discs, there are actually different muscles which are innervated by specific discs, disc area nerves. So for instance, if a person has I'm just going to give an example. If a person has an MRI and it's showing damage to the C5 disc area, that can cause sharp shoulder pain, but it isn't likely to be the cause of the claimant experiencing the pain radiating all the way down into their hand, which would be more likely to be a C6 disc area. Now, if you go online, you can find an awful lot of information about which specific disc areas innervate which specific muscles. There are many, many different segments of the body that it's broken down into, and you can find specific information about which disc will correlate with the manifestation of symptoms in which specific area. So ultimately, it can be extremely important to do thorough enough medical research in order to show that the claimant is actually presenting with truly correlating symptoms to the medical imagery you have. You need to really be able to know for sure that they are getting the severity ranking that they truly deserve. Ultimately, it is has the potential to save the carrier an awful lot of money if that is done appropriately versus kind of generically. Thank you.
Hi, everybody. This is Melissa Day again, and I'm here today to tell you a few of my favorite things related to how the board is interpreting schedule loss of use awards since the 2018 or 2017 permanency guidelines were updated for schedules. I've taken these from the frequently asked questions section on the board's website. There's a wealth of information in that section about how the board is interpreting the schedules since the new guidelines came out. And I've also done a little bit of research just to enhance some of the frequently asked questions and answers that the board provided on the website. So here we go. 10 things about schedules that I think are good news for us from the defense side of the bar. The theme for our new schedule loss of use interpretations and guidelines is that the doctor must provide the schedule opinion only for the work-related injury. So what does that mean? Well, if the claimant's range of motion is limited by a non-occupational condition such as obesity, then the doctor should offer the opinion related only to the occupational injury. So if the claimant only has range of motion as a result of a non-occupational condition like obesity and limitations in the range of motion prior to the work injury, that loss of range of motion should not be included in determining the schedule loss of use. Same thing with respect to a condition like osteoarthritis. So if the claimant has an injury which is an exacerbation of a pre-existing osteoarthritic condition, and who hasn't seen one of those, and then the claimant ends up with a loss of range of motion following a work-related injury, we're only supposed to take a look at the loss of range of motion and the effects of the injury when determining permanency. Well, how do we do that? Well, you want to make sure that we have some evidence of what the loss of range of motion was prior to the injury, or by measuring the contralateral side. Unfortunately, the contralateral side is only useful to us if it was uninjured. And so if possible, and you have a contralateral side that had an injury such that you wouldn't be able to use it to limit your schedule loss of use award, I recommend that you get previous medical records or a post-offer employment physical to see if there's some information about loss of range of motion before you have your permanency evaluation. The second favorite thing I have about schedule losses of use since the board changed the guidelines is that if the claimant was previously awarded a schedule loss of use and then has a subsequent injury and there's no change in the loss of range of motion following the second injury, then the claimant should not get an additional schedule loss of use above and beyond what they already had, unless there's some sort of special consideration which might lead them to get one specific to a procedure or a specific type of injury. So that's good news. The claimant has a subsequent injury and there's no additional loss of range of motion from a previous schedule loss of use, no additional schedule loss of use award. The third favorite thing of mine following the board's change of the permanency guidelines is that if a claimant receives or achieves full range of motion after an injury, and again, there's no surgical procedure which has attendant to it in the guidelines, some specific finding which should lead to a permanency award, the claimant's not entitled to a schedule loss of use award. So just because the claimant has a surgical procedure, if they are able to achieve full range of motion following that surgical procedure, then there is no schedule loss of use unless the surgical procedure itself is identified as a factor in determining the permanency award. So this is great for those people who have fit for duty evaluations, and when they want to go back to work, they're able to move their arm in any which way, but then when they go to the IME doctor, they're very limited in what they can do. If they're actually able to achieve full range of motion, they don't get the schedule. My fourth favorite thing is that when there are reductions in range of motion on the contralateral side and there hasn't been an injury to account for that range of motion loss, then you would be able to reduce the loss of range of motion in the affected side. So, for example, if I am only able to lift my uninjured left arm to approximately 135 degrees, and I can only lift my injured right extremity to, say, 120, 125 degrees. If I was able to achieve full range of motion on the left, that would be fairly significant loss of range of motion. But if we start from here, the loss of range of motion is fairly modest. And the board's frequently asked questions section explains that the purpose of the measuring the contralateral side is to reduce the overall loss of range of motion on the injured side. So that's another one of my favorite things. Again, you want to get prior medical records in order to be able to substantiate that, even if the previous side was injured. If you can start from a reduced range of motion finding, then the affected range of motion will hopefully be less. My fifth favorite thing is that the attending physician who treated the injury is the one who is expected to do the permanency evaluation. So it's fine if the claimant wants to go to a different physician to have the evaluation done for the permanency finding, but if it is not the doctor who treated the claimant all along, then it would be my position that that doctor would have to follow the limitations and requirements under Section 137. It's not just for our side. Claimants' doctors who perform independent medical examinations and that they're not treating physicians also have to follow the rules of Section 137. My sixth favorite thing about the way that the board is interpreting the guidelines is that all three range of motion findings that are required under the new guidelines have to be on the report. There's a particular doctor in the Buffalo area who will remain unnamed, Dr. Grant, who frequently claims, even though he has one range of motion finding in his report, that he actually performed three range of motion findings. Well, we being the suspicious types did not believe him, and so we have subpoenaed his notes from those types of evaluations. But if you can, what you should argue in front of the judge is that those range of motion findings have to be in the report, and that's per the frequently asked questions section that the board has published on its website regarding schedules. The same thing is true with respect to the range of motion findings on the contralateral or unaffected side. And finally, the doctor has to use a goniometer, and if the report does not reflect that the doctor used a goniometer, then we have a good argument that the report is defective. Speaking of that, another one of my favorite things is that if the board has issued an EC 81.7, or if you have received a report that does not detail all three range of motion findings, you have a good argument that that report is defective. And as a result, you shouldn't be required to go out and expend money on an IME until the claimant has produced credible medical evidence of permanency. And as a result, we would recommend that you not go out and get your IME, but rather file an RFA or write to the board and take the position that the medical report is not credible evidence of permanency pursuant to the 2018 guidelines, and as a result, it's your position that you're not getting an IME. The doctor, here's I jumped around a little bit, so I'm a little bit unsure as to which number of my favorite things I'm on, but one of my other favorite things is the doctor should use active range of motion, not passive range of motion. And I like this because if you can get some evidence that the claimant is being uncooperative during the examination, the IME doctor should note that in the report and not provide a scheduled opinion. One of the reasons you would not want your doctor to provide an opinion based on a claimant's presumed lack of cooperation is that the board actually has found that a claimant's refusal to cooperate with range of motion testing for a permanency evaluation is tantamount to the refusal to submit to an IME. And under Section 13 of the Workers' Comp Law, the refusal to submit to an IME leads to preclusion of any benefits following the refusal to cooperate. So that's one of my favorite things is that we have frequently some strong evidence that the claimant's sandbagging when they go in for their IME. And if that is the case, then we have an argument that the claimant is failing to cooperate with the evaluation. And you should get PT records to help bolster that kind of an argument, because frequently after surgery, when the claimant participates in PT, we find that they have fantastic range of motion, or at the time, again, when they're looking to return to work for a fit for duty evaluation, they have great range of motion, and it's not until the IME, when it could result in some pecuniary gain, that the claimant all of a sudden can't lift their arm over their head. Another one of my favorite things is that although the board frequently does accept the reports of nurse practitioners and physician's assistant, as long as it's countersigned by a doctor when determining things like causal relationship and degree of impairment at the board, it is not acceptable for a permanency evaluation to be submitted by a nurse practitioner and presumably a physician's assistant, because the board treats them the same. It is not okay for a nurse practitioner or a physician's assistant to sign off on a C4.3, even if the doctor signs off on it. So that would make it defective as well, and we would recommend the same response as when you receive a defective report, because there haven't been a sufficient number of range of motion findings. Finally, somebody locally here reminded me the other day about this great new decision that we have called Genduso, I think is how you would pronounce it, versus New York City Department of Education. And this is a case that was brought to our attention by General Counsel David Wertheim at the Buffalo Claims Association Education Day. And that case holds that, it's a third department case, that case holds that if you have a previous schedule to the leg as a result of an ankle injury, and then you have a subsequent claim involving a knee, which would again lead to a schedule for the leg, you get a credit against the subsequent schedule as a result of the knee injury from the previous ankle injury schedule. And that's because they're both schedules to the leg. The interesting thing about that scenario and the court's holding is whether or not that would apply to the same injury. The guidelines right now provide that when you have multiple injuries involving one extremity and the same part of the extremity, so for example, if you have one claim where you had an elbow injury and a shoulder injury, the guidelines actually say that if it is a high or a significant schedule, then you're supposed to take the highest value of the arm and then, or the extremity, and then add additional percentage up to 10% for the other schedule, which raises an interesting question, because the board has applied Genduso to find that previous claim where you get permanency from the elbow, and then on a subsequent claim for an injury to the shoulder, you should be entitled to a credit for the previous schedule to the elbow on the shoulder claim. So why would you treat identical injuries that happen on one claim any differently? And I believe that we can make the argument under Genduso that that disparate results for the very similar injuries should not be countenanced, and as a result, application of the guidelines, unless it is a significant injury, should be limited to the greater of the two schedules. In other words, the elbow injury should lead to a 20% schedule, the shoulder injury should lead to a 30% schedule. It would be my position that at most the claimant can get the 30% schedule based on the shoulder injury. And that's if they're at the same on the same accident. So those are my 10 favorite things on schedule losses of use since the board has changed the guidelines and issued this new frequently asked questions section on the board's website. And I'd ask you to stay tuned to the additional attorneys that I have in the office who will be providing you with their favorite things on their topics. Thank you.
Hi, I'm Shannon Mackey, and I was introduced in the last video with Melissa as one of the newer associates. And I'm here to talk about my favorite thing in comp. And my favorite thing in comp relates very closely to my favorite year, which was when I turned 18. I got to be a freshman at Notre Dame. I got to vote. I got to drive because I'm from New York City. And everyone agree, 18th birthday is usually a pretty good time. Well, in comp, the 18th birthday of a claim is also a pretty good time too. The 18th birthday of a case is when Section 123 can apply. There are 3 parts to Section 123. I'm only talking about the part which is the 18 and 8 bar on future indemnity in the file. When a file becomes 18 years old, if certain criteria are met, the board no longer has jurisdiction to award any indemnity. Medical awards are never affected by a finding of 123 under this 18-8 period. It is only the indemnity awards. And what has to happen in order for that to apply is that it has to be 8 years since the last payment of compensation. And I'm going to talk about that in a little bit, because even if it looks like you paid within the past 8 years, you might not have. Also, the case has to be meet essentially the same criteria as Section 25A, which is true closure. There has to be no application to reopen within the 18 years since the date of accident, or the 8 years, and there has to be 8 years without compensation. And there has to be no advance payments of compensation in recognition of your indemnity. Now, it doesn't matter if you've been paying medical for this whole time. We're specifically talking about indemnity. Some things to note. As I said before, the reason I would recommend not saying Section 123 applies just because you've been paying is because if you haven't been under a specific direction to pay, or even if you have been given a direction to pay, if it was improper and Section 123 should have applied, you cannot be found to have waived Section 123. Section 123 is a jurisdictional issue. It can never, ever be waived. So 2 cases we have. One is a case where Section 123 should have applied. The claimant a claim was brought for lost time. The attorney at the hearing stipulated to the awards and agreed that the claimant should be paid. The stipulation was done in writing and signed by all parties. No exception was noted at the hearing. And about 3 months later, everybody realized that Section 123 should apply. So an appeal was filed very, very late, noting that under the board's jurisdictional rules, that indemnity payment cannot have been made. And the board agreed and rescinded the awards, and Section 123 applies. So this is one of those things that, 123 can apply. You cannot mess it up. Another case, they actually paid the awards on a voluntary basis following a surgery. And they realized after they began those payments of awards that Section 123 should have applied prior to the surgery authorization. And, raised 123, the notice of decision, the judge found that 123 didn't apply because they had voluntarily picked up those payments. And the board reversed, indicating that it is a jurisdictional issue and you cannot waive 123, not on purpose, not on accident. It applies. The thing to note, what you should do, if you have a case that's about to, reach its adulthood in workers' comp of 18 years old, you really should be looking at it kind of the year or two before, either 16, 17, the cusp of adulthood, as you will, in order to see if it's ready for Section 123. You don't want to have any outstanding issues hanging open, such as requests for surgeries, changing conditions, periods of lost time that maybe were from 10 years ago that weren't actually finalized, opinions of permanency, even if the claimant isn't being paid. All of those things can bar a finding of 123. So what you really want to do is send those files for review in order to determine whether Section 123 should apply. And a lot of people know I came from special funds after 6 years. Melissa, I believe, started at special funds, and she did a lot of the appellate work on all of this law. And we have Tom Dickinson as well. So I would recommend sending your files to us for review around 16th or 17th birthday in order to see if 123 can apply and allow us to induce the closing to make sure that it could. This is something that a lot of carriers' councils have never dealt with, and a lot of carriers have never dealt with, because for years, if 123 applied, then as a matter of law, Section 25A would have already applied prior to that. So basically, you would have raised 25A, and we would have taken care of the 123 finding. So at special funds. So it's definitely something that's worth looking into. And the 16th and 17th year is when we at special funds would start looking at files with an idea to close them in order to make sure what Section 123 would apply when appropriate. So again, and also as another note, you don't actually have to raise 123 when it should be apply. You really shouldn't raise it until a claim for indemnity is made. It's not actually ripe until that point, so you just kind of hold it in your back pocket. If we are on for a hearing and 123 should apply, we might raise it, but the judge usually won't find on it, which is proper, until there is a claim made. So it's not something you have to file an RFA2 on or take any action on other than to induce the closing. So thank you.